not evidence. They're only meant to help you understand how each side views the case. To prove the charge of homicide, first-degree murder, the prosecutor must prove the following elements beyond a reasonable doubt. First, that the defendant caused the death of April Dawn Millsap. That is, that April Dawn Millsap died as a result of blunt head trauma and asphyxia due to neck compression. Second, that the defendant intended to kill April Dawn Millsap. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. Fifth, that the killing was not justified, excused, or done under circumstances that reduced it to a lesser crime. The defendant is charged with a first-degree felony murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. So you're not distracted. You are going to get this in writing. Once I complete it, we're going to take a break, and I will get you copies of these elements so that you're not frantically writing. So I will give you copies of everything. First, that the defendant caused the death of April Millsap. That is, that April Millsap died as a result of blunt head trauma and asphyxia due to neck compression. Second, that the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to April Millsap, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that when he did the act that caused the death of April Millsap, the defendant was committing or attempting to commit the crime of kidnapping and or the crime of larceny. First, for the crime of kidnapping, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant forcibly confined or imprisoned April Millsap against April Millsap's will. Second, that the defendant did not have legal authority to confine April Millsap. Third, that while he was confining April Millsap, the defendant forcibly moved or caused April Millsap to be moved from one place to another for the purpose of kidnapping or to murder April Millsap, or intended to commit a sexual penetration or to get money or other valuables from April Millsap. Fourth, that the defendant intended to kidnap or confine April Millsap. Fifth, that the defendant acted willfully and maliciously. This means that the defendant knew that it was wrong to confine April Millsap, and knowing that he did not have the legal authority to do so. For the crime of larceny, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant took someone else's property. Second, that the property was taken without consent. Third, that there was some movement of the property. It does not matter whether the defendant actually kept the property or whether the property was taken off the premises. Fourth, that at the time the property was taken, the defendant intended to permanently deprive the owner of the property. Fifth, that the property had a fair market value at the time it was taken of less than $200. Fourth, that the killing was not justified, excused, or done under circumstances that reduced it to a lesser crime. To establish an attempt, the prosecutor must prove beyond a reasonable doubt that the defendant intended to commit the crime of kidnapping, larceny, and that he took some action toward committing that crime, but failed to complete it. It is not enough to prove that the defendant made preparations for committing the crime. Things like planning the crime or arranging how it will be committed are just preparations. They do not qualify as an attempt. In order to qualify as an attempt, the action must go beyond mere preparation to the point where the crime would have been completed if it hadn't been interrupted by outside circumstances. To qualify as an attempt, the act must clearly and directly be related to the crime of kidnapping and or larceny and not some other objective. The defendant is charged with the crimes of kidnapping. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant forcibly confined or imprisoned April Millsap against April Millsap's will. Second, that the defendant did not have legal authority to confine April Millsap. Third, that while he was confining April Millsap, the defendant forcibly moved or caused April Millsap to be moved from one place to another for the purpose of kidnapping or to murder April Millsap, or intended to commit a sexual penetration or to get money or other valuables from April Millsap. Fourth, that the defendant intended to kidnap or confine April Millsap. Fifth, that the defendant acted willfully and maliciously. This means that the defendant knew that it was wrong to confine April Millsap and knew that he did not have the legal authority to do so. The defendant is charged with the crime of assault with intent to commit criminal sexual conduct involving sexual penetration. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant either attempted to commit a larceny on April Millsap or did an illegal act that made April Millsap reasonably fear an immediate battery. A battery is a forceful or violent touching without lawful consent of the person or something closely connected with the person of another. Second, that the defendant intended either to injure April Millsap or intended to make April Millsap reasonably fear an immediate battery. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability, or thought he had the ability. Fourth, that when the defendant assaulted April Millsap, the defendant intended to commit a sexual act involving criminal sexual penetration. This means that the defendant must have intended some actual injury into one person's genital opening and or anal opening and or mouth with another person's penis and or finger and or tongue. It is not required that the defendant actually begin to commit the sexual act. To prove this charge, the prosecutor must prove that the defendant made an attempt or a threat while intending to commit the act. An actual touching or penetration is not required. To prove this charge, the prosecutor must prove that the defendant committed the assault and intended to commit criminal sexual penetration. So I've read to you the elements. Next, the prosecutor, and I'm reading, let me see where I'm at here. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, these are not evidence. They're only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. You will be given a written copy of these instructions I've just read to you, and you may refer to them during the trial. Since no one can predict the course of the trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a copy of my final instructions for your use during deliberations. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses' questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss the case with anyone, including your family and friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all of the jurors are there. When the trial is over, you may, if you wish, discuss the case with anyone. If I call for a recess during the trial, I will either send you back to the jury room or allow you to leave the courtroom on your own and go about your business. Or you must not discuss the case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop and explain that as a juror, you are not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. You must not talk to the defendant, the lawyers, or the witnesses about anything at all, even if it has nothing to do with the case. It is very important that you only get information about the case in court when you are acting as the jury and when the defendant, the lawyers, and I are all here. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information, that might unfairly favor one side. So, to be fair to both sides, you must follow this instruction. Remember, for the reasons I explained to you earlier, you must not read, listen to, or watch any news reports about this case while you are serving on this jury. The only information you will receive about this case will come to you in this courtroom. You must not consider any information that comes from anywhere else. You must not, again, read newspaper headlines or articles relating to the trial. Also, you must not watch or listen to television and radio comments or accounts of the trial while it is in progress. Until your jury service is concluded, you are not to discuss the case with others, including other jurors, except as authorized by the court. You are not to read, I know it's becoming redundant, but I have to put it into your heads. You are not to read or listen to any news reports about the case. In this case, we are asking you specifically not to watch the following television shows while sitting as a juror: CSI, all versions; NCIS, all versions; Castle, Making a Murderer on Netflix, and Criminal Minds. I'm going to read them again. CSI, all versions; NCIS, all versions; Castle, Making a Murderer on Netflix, and Criminal Minds. You may not use a computer, cellular phone, or other electronic device with communication capabilities while in attendance at the trial or during deliberations. These devices may be used during breaks or recesses, but may not be used at any time to obtain or disclose information about a party, witness, attorney, or court officer, news accounts of the case, or information collected through juror research on any topic raised or testimony offered by any witness or by any exhibit. You must not visit the scene of the occurrence that is the subject of this trial. If it should become necessary that you view or visit the scene, you will be taken as a group under my supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not do any investigations on your own or conduct any experiments of any kind. This includes using the internet for any purpose regarding this case. If you discover a juror has violated my instruction, you should report it to me. You may take notes during the trial if you wish, and of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see that we've chosen a jury of 14. After you've heard all the evidence and my instructions, we will draw lots to decide which 2 of you will be dismissed in order to form a jury of 12. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial, and at the end of the trial, I will give you detailed instructions about the law in this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After all the evidence has been presented and the lawyers have given their arguments, I will give you detailed instructions about the rules of law that apply to this case. Then you will go to the jury room to decide on your verdict. A verdict must be unanimous. It means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. So we're going to need 5 minutes to get the rest of these instructions copied up for you. And we're going to return at about 2:20, 2:25 for opening statements. So please stay in the jury room. And if I didn't tell you, you're more than welcome to bring whatever it is you like to drink in the courtroom. And if you have things that you want me to refrigerate, I certainly have the ability to do that. Does anybody have any questions right now before we take this break? Okay, we're going to take our break, and we'll get you your jury instructions.
All rise for the jury.
You have like 4 of your sheets?
Just the,
We'll take them on in and
yeah,
have them in
214,
14 packets.
216, and then
Try the thermometer out when you're healthy so you get a baseline temperature. So many